Okay, everyone, just me, JP Donnelly, Jeff Donnelly, Jeffrey Paul Donnelly, JP Donnelly 8 at .com, JP Donnelly 8 YouTube, JP Donnelly 8 just about everywhere. Okay, also author of Motion of Political Repression, The True Tale of Massachusetts Bohemian, the book I wrote detailing, it's a journal detailing corrupt acts when I was 25 years old that the Commonwealth took when I tried running for Congress. You know, it's got statements, it's got police reports, it's got the good, the baddie, and the ugly. Plain and simple, from A to Z. Okay, and yeah, so what we're going to talk about today is, as some of you may know, I have a jury scheduled for April 28th in Springfield District Court. And this case resolves around the firearm incident, issue, where basically they are charging me with refusing to turn in a Class A firearm license. Well, there's a few issues with that, as you're already probably aware, such as the issue where my firearm license expired on April 24th of last year, and I sent in the renewal paperwork. They sent me back the renewal paperwork with the uncashed check, which means they didn't accept my renewal. And yeah, on May 7th or so, or May 8th or whatever, when they contacted me via the telephone, telling me that my firearm license was revoked, I explained to them I didn't have a firearm license in Massachusetts anymore because it was expired. So why would I turn in an expired license? And remember, this happened on a Friday night that they called me up. So, yeah, they weren't looking for an expired license. They were looking to arrest me because I was refusing to turn in my lawfully owned firearms as well. Even though in the application that I had actually sent in on April 23rd, I explained to them that if my firearm license was not renewed, that the firearms were going to be moved to a state where I was still allowed to own in. And actually the firearms were removed to that state that I was still allowed to own firearms in, under that state's law, being Vermont. Also being the state that the Springfield Police Department illegally confiscated the firearms out of, in violation of Vermont law. Okay, so we're going to talk about the trial that I have on the 28th. So, the pretrial conference, right, where basically the judge says what you can and can't bring in as evidence, and who you can and cannot bring in as a witness. I intended to call several state agents, most state employees, mostly the district attorney, the assistant district attorneys who were involved in the Palmer case and the Munson case, because I wanted to show a pattern of corrupt behavior by these state agencies testifying, as well as the probation officer that contacted me the day after I contacted the district attorney Giuliani's office asking to meet with him about the corruption I was facing and about these cases. Being a pro se litigant, I'm entitled to actually meet with the district attorney in order to discuss these cases. But instead of actually replying to me, it appears that the district attorney had a probation officer contact me in order to inform me that I was on probation, even though there's no paperwork ever putting me on probation. And I've never been found guilty of any criminal offense to be on probation or have a probation officer having to check in and such. Yeah. Okay, well, so those people, I had a feeling that the judge wasn't going to let me to, call in as witnesses. So I decided to just test the water a little bit by asking to be able to be allowed to call Assistant District Attorney Hobbs as a witness for examination in order to show corruption. And you may ask yourself, well, what would you really have the assistant district attorney handling this case, this present case? What could he really testify to that would show anything that was at least questionable on his behalf? Well, this is what I planned on actually asking him when he was on the stand. Number one, when they had me arrested, I was in the Ludlow House of Corrections on a Zoom hearing in order for a bail hearing in the Springfield case. So what he did is, with the public defender that they gave me for that, for that hearing, he had told her that he wanted a $500 cash bail. And I had talked to her, like, you know, through like the Zoom prior to, you know, the case being called in Springfield District Court through Zoom. And she's telling me, she's like, well, they want you held on a $500 cash bail, blah, blah, blah. You know, like, do you know anyone that has $500 that they could actually put down for a $500 cash bail? I'm like, honestly, I'm like, the only person I know that could actually furnish the $500 cash bail is myself. Like, I would have to actually do it through my, like, you know, debit card, but my debit card with my wallet is in the Wilbraham Police Department, so someone would have to get my wallet and get my debit card, access to my debit card to do that, because I could do that myself. Like, I could self-fund a $500 cash bail if need be. She's like, well, anyone else? I'm like this? No, I'm like, you know, my parents don't have it. If need be, I could furnish, you know, I have the $500 I could actually provide for my freedom. So, about half an hour later or so, we go before the judge, and Assistant District Attorney Hobbs is now asking for $5,000 for a cash bail. He went from $500 to $5,000 after I had told my, you know, public defender that I could actually pay the $500 if need be. You know, but I'm like, but at the same time, like I had told her, I'm like, hey, I'm like, I've always shown up to court. I've never not shown up to court. Even with the Palmer case, I told her, I'm like, I was notified for the first time, like on a phone conversation from the Munson Police Department saying, were you aware that you had court today? And I'm like, I'll be right there. You know, like I dropped everything I was doing and beeline to the courthouse like an hour later, half an hour later, in order to actually present myself. Like, which shows that there's no reason to believe that I wouldn't show up to court unless I was, you know, held on bail or had bail holding over my head. So, ADA Hobbs changed that to $5,000. I was released on my personal reconnaissance, you know, thank God I didn't have to pay the $500, you know, because that really would have squeezed me a lot financially. But a $5,000, you know, cash bond bail, I would have never been able to pay. So they would have had me still locked up right now over $5,000 that I wouldn't be able to have paid on a case that shouldn't even exist, because, you know, on May 7th, May 8th, I didn't have a firearm license. I didn't have a valid firearm license to actually turn into the Springfield Police Department, and they were aware of that. They also didn't put in the paperwork, you know, with the court, you know, in their application that the firearm license was expired. They said it was a valid Class A license to carry when it was expired. So, yeah, amongst other things, they lied about to the, you know, court as well. So, ADA Hobbs had actually told me that the reason why he changed it from $500 cash bail to a $5,000 cash bail was because his boss told him to. His boss is the district attorney, an elected official with very close ties, I've been told, to Richie Neal, a very corrupt individual in my own view and the view of a lot of others. You know, look at what he did to Alex Moore when Alex Moore ran against him, you know, for Congress. He destroyed the guy. And I don't mean politically. I mean, Richie Neal's machine actually destroyed the kid's reputation and everything else. Okay, so, you know, like, also ADA Hobbs had offered me 1 year pretrial probation, and then he changed it to 1 day of pretrial probation, even like 1 hour of pretrial probation, to settle this case without a trial. If you look at pretrial probation, that's a joke. It's nothing. It's not even like a piece of toilet paper landing on your wrist. It's not even a slap on the wrist. What it is basically ending a case on a non-guilty plea, you know, non-guilty. You know, it's like, okay, I'm ending this without, you know, a guilty finding, and I'm saying I'm not guilty. It's a heaven sent for anyone that's been found guilty of a crime or alleged to have been, you know, having committed a crime. The reason why I didn't accept that is because the only thing I'm willing to accept is them dropping the charges, because I did nothing wrong. Yet they lied on a police report to Springfield Police, had me arrested for no reason. My clothes were cut off me in the Ludlow House of Corrections. And from 3 o'clock in the morning until about 8 o'clock at night, I was in the house. I was in the Ludlow House of Corrections for no reason. They took my freedom away and they filmed me naked and shit. So yeah, I'm not gonna just it's like either drop the charges or we're taking this to a trial. And then on top of it, now, when we went before the judge was like, well, is there like any plea offers, blah, blah, blah. And the ADA Hobbs actually said, he's like, Your Honor, he's like, I offered this, I offered that. But as of right now, there's no offer on the table because my boss made me, told me that I could no longer offer those pleas in this case. Okay, so there's a lot of activity going on in the Hampden County District Attorney's Office involving myself. So I wanted ADA Hobbs to actually take the stand and to actually talk about and answer questions in regards to these illegal activities that have been perpetrated against me by the Hampden County District Attorney's Office. And when I say illegal, I mean really malicious prosecution, because the Munson case and the Palmer case have already been dismissed, which is now opens them up to malicious prosecution. But the judge said I cannot have Assistant District Attorney Hobbs take the stand. And that right there would have proved a continuance of malicious prosecution and other illegal activities perpetrated from the District Attorney's Office against myself. Because remember something, the Hampden County District Attorney's Office are the ones that contacted contacted Munson and told them to file charges against me from the false allegation from over 5 years prior. They're the ones that made Lieutenant Gasparini file these charges. I was also arrested on a day in Palmer District Court where I was supposed to have a motion to dismiss hearing for the same reason that the case ended up being thrown out of Palmer District Court, the Munson case. But the court officers explained to me previous to my being arrested that the Assistant District Attorney, in that case Joyce, wasn't prepared to go forward with the motion to dismiss that I filed. That was probably about 200, maybe 300 pages long, including exhibits. So if she wasn't ready to go that day, she had to do something. They had to do something. The court had to do something in order to not have that motion heard. What did they do? They arrested me. And what did they say in their internal documents why I was arrested? Well, they claimed in their internal documents that I was asked to leave the courthouse. They told me that they would come and get me when my case was heard, and that I told them that I did not trust that they would come out to my car and get me when my case was heard, and that's why I wasn't leaving. That's why I was arrested and charged for that case. And when I was called up later on that day from the holding cell, the judge said that ADA Joyce had already left for the day. So my case was called, and they didn't bring me upstairs for it. Kind of strange, huh? And then that case was dismissed as well. So, ADA Hobbs would have been testifying to what was going on in the district attorney's office concerning myself. I figured as soon as I got him allowed on there on the witness list to be valid, I was going to have the district attorney on there, I was going to have ADA Joyce, and I was going to have the other ADA that handled the other case in Palmer. Okay, so nope. The judge says that ADA Hobbs was not allowed to be on the witness list, be called as a witness in my case. So what did I do then? I asked for Heather O'Keefe, the one who made the false allegations against me in the Palmer case over 5 years prior, and also made other lies in her witness impact statement, and also other lies including other individuals in other cases not involving mine. But I was going to show the history that this person has, plus the fact that they're a heroin addict, and they were, they should be a sex offender. They should be a registered sex offender because when she was in her early 20s, she was dating a 15-year-old boy who she was also she was taking all of the kid's money, and even every dime that the kid made was going to her. So she was not only sleeping with a minor who was 15 years old, but she was also stealing the kid's money. And his mother wrote an official police report, statement, complaint, saying that she wanted her charged for contributing to the delinquency of a minor, because she was also having the kid skip school to babysit her daughter, and also for statutory rape. But for some reason, she was never charged with that, even though I have the statement from the kid's mother begging with the police department to charge her for that. Also, I've got the statements that show that she's a convicted felon for lighting her car on fire for the insurance money. I have the whole police documents where she claimed that she was going to, if she was ever caught, that the person that helped her, she was going to claim that he raped her if he ever turned on her. Like that she said this stuff to her friends. I have her friends' statements against her. I have the fact that she had lied on, she had been found guilty of a felony for lying to the police in official statements, false reports to crimes, and all of this other stuff. And that's all when she was in her 20s. Plus, I have false statements that she made after the 5 years, like after the whole situation with me and her. False statements that she made against the other places she had worked afterwards, and against former co-workers, and reports that she had made to the police department, like that. Honestly, reading them, I think it's insurance fraud that she was reporting. Lawsuit against lawsuits showing that she claimed that the Magic Lantern had taken her shifts after she made the complaint against me, when in fact her shifts were taken before that. Like, bunch of stuff. So I was going to call her as a witness in order to show how, the reason why they claimed it was suspended in the official paperwork until the Palmer case was over would have showed that I had no really reason to fear the Palmer case going any other way than a motion to dismiss, or me being found not guilty because this individual who made the false allegations made it for money, and they're completely a complete mess, at least in my view. And the paperwork I have, I believe that they're a complete, utter piece of human filth, garbage. Okay, so that person right there, they're like, well, the ADA, the assistant, the ADA Hobbs, like, Your Honor, she has nothing to do with this case. She should be not allowed to testify. It's like, yo, what do you mean? Like, the Springfield police said that it was suspended until the Palmer case was over. So if she's the main reason behind the Palmer case, I believe that right there should be able to be brought in as a witness in this case in order to testify, in order to prove that I had nothing to fear about. And, come on. So the judge is like, well, if you want to call this person in, if you want to call Miss O'Keefe in as a witness in this case, we're going to have voir dire, where we're going to limit what you can ask this person, and about what you can ask this person. It's like, hold on. Really? So hold on. I'm going to bring this person in. And not only am I going to have one hand tied behind my back, but I'm going to have both of my fucking hands tied behind my back. I'm going to bring this person in and not be able to ask them and examine them on all of these situations. Being the convicted felon for a couple cases. Lying to the police. Lying to the courts. Being a sexual predator. Being a heroin addict. Lying about, everything. So it's like, I'm going to bring this person in. I'm not going to be able to ask them any questions in order to disprove anything that they had alleged. But ADA Hobbs is going to sit there and cross-examine this person and get the information, get the partial information out that's going to make me look like shit. But not allow me to show the truth about the situation. Yeah. So that right there means, I can't have this person testify because the judge is sitting there tying my fucking hands behind my back. And then how about this one? Remember something. On the phone call that the Springfield Police Department made to me, they said that my firearm license was revoked due to the Palmer case, and that they had no control over it because it's an automatic disqualification. Because the Palmer case is the reason why my license was revoked, because they have no choice than to revoke it due to the Palmer case. Remember something. I went into the Palmer case without even knowing that I had an arraignment that day, until right then and there. I had no idea what the charging statements even said. I had no attorney. It was just me. And like, they gave me some kind of public defender just to like say, don't send him to jail. He'll show up to court. He showed up right now. Like, just, yeah. So, what I wanted to bring in as evidence, because they're claiming, and ADA Hobbs is still claiming, that with the Palmer case, I automatically had to turn in my firearm license as part of that case. Springfield PD claims it. ADA Hobbs claims it. But there's a problem. I tried to enter in the order of pretrial conditions of release from the Palmer case, which is docket number 214-3 CR 501 out of Palmer District Court. Okay. So what it says here is, failure to obey this order may result in your arrest and incarceration. To the defendant, it is hereby ordered that you must comply with all pretrial conditions of release that are checked or filled in below, pursuant to, as checked off, General Law Chapter 276, Section 58. Specified restrictions on personal association or conduct, or in cases alleging domestic violence, or to ensure the safety of alleged victim, any other individual, or the community. Okay. So they checked off these right here. Obey all local, state, and federal laws and court orders, including abuse and harassment prevention orders and support orders. Notify the probation department immediately if you change your residence, mailing address, or contact information. Make no false statements to any officer of the court. And then it says, also checked off, refrain from abuse or harassment of alleged victim. Have no contact, direct or indirect, with alleged victim. Okay. But you want to know what isn't checked off? And remember something. The assistant district attorney handling this case could have easily asked the judge to have this checked off, and the judge would have automatically rubber stamped it for the most part. Maybe not because it was an allegation from over 5 years before, but who knows? There was always that possibility that the judge would have rubber stamped it. But what is not checked off is surrender all, refrain from possession of any firearms, rifles, shotguns, destructive devices, or dangerous weapons. That's not checked off. And remember something. ADA Hobbs is claiming that I wasn't supposed to be, I was automatically disqualified from owning firearms because of this case. The Springfield Police Department claimed that I was automatically disqualified from owning firearms as part of this case. Why did Judge McKenna refuse to allow me to enter this in as an exhibit for the trial? Why? You want to know why? Because it's going to show that the city of Springfield is lying and ADA Hobbs is lying if it was entered in. You know, the judge's like, you know, then the judge had said, he's like this, well, like, you don't want to enter that in. You don't want to enter it in because it says what you were charged with. You know, you don't want them knowing what you were charged with. Well, there's a problem here. He's allowing me to enter in the renewal application I sent in that they sent me back, which stated what I was being charged with because I had notified the Springfield Police Department. You know, in my renewal application I sent in on April 23rd, day before my birthday, day before the firearm license expired, I stated what I was being charged with in that. I also stated in another, I believe, piece of paperwork that I was entering into it as an exhibit what I was being charged, what I had been charged with in the Palmer case, in the Palmer case out of Munson. All of that information was in those documents. But this document right here does not say what the alleged crime that I was facing was or is. But yet the judge was acting as if he was protecting me by not allowing me to enter in this document as an exhibit. That's not protecting someone. That's covering up for the Springfield Police Department and the Assistant District Attorney and corruption in the courthouse. It's a cover-up. Why? Because this document shows that as part of the Palmer case, I wasn't required to turn in my firearms. You know, like, on top of it, jury instructions. You know, jury instructions are a major, major thing when it comes to a criminal activity. The Assistant District Attorney wrote out several pages of jury instructions. Several. Many pages. All of them were very confusing to the average person. I read them and they made no sense because, you know, they made no mention of dates or anything like that. And dates are important in this case. Because the city of Springfield suspended my firearm license on, let's just say, April 12th. But Massachusetts General Law, Chapter 140, Section 131, License to Carry Firearms Condition Restrictions, says that they have to provide you with the revocation or suspension in writing, giving you the reasons why, so you can appeal it. Well, they never gave me that. The date of the suspension letter, remember something they filed, the charge is saying it was revoked, not suspended, but the suspension letter that I did receive after I was charged and arrested and went to the police department and ordered and demanded that they provide me with that letter, which you'll see in one of these videos from like months ago when I filmed it and when I actually got served in hand. Well, that general law clearly states that I'm supposed to be served in hand prior to being arrested or anything else. But no, they didn't do it. So if you look at it, if they enter that as an exhibit, which is the only thing they plan to enter in as an exhibit, that has a date of April 12th or something, maybe April 14th or whatever, something like that. The problem is they never served it on me. They never provided me with that letter in April. They gave me the letter in mid-May when I demanded that they actually give me the letter so I knew exactly what was in it. So, if the jury believes that I was provided with that letter in early April, like April 12th or whatever, they're going to find me guilty because they're going to believe that I was served with that letter under how the law stipulates. But if the jury is asked if I received the letter in mid-May, after my firearm license already expired, after I was arrested, they're going to have to find not guilty. You know, like after April 24th, my firearm license expired. So with the jury instructions that he's trying to, you know, make the judge use, it clearly states no dates in order to confuse the jury into believing that as long as that letter exists, they need to find me guilty. And the judge completely threw out my jury instructions and said he was making his own jury instructions, which has me worried because he's already not letting me bring in people to testify. He's already not allowing me to show the jury paperwork that shows that I was legal. You know, and another thing. ADA Hobbs clearly actually bold-faced lied to the judge and the judge did nothing about it. Like you mentioned 140, 131C, right? Well, 140, 131, saying that the firearm license is good for 60 days. No, 90 days after the expiration, which that's not what the law says. The law clearly, dictates that that's not what it says. But like, all right. Basically, he also mentioned Commonwealth versus Farley, which I had no idea about because he never served me with a motion to an opposition motion to my motion to dismiss, which would have laid out what case law he was claiming. But he claimed Commonwealth versus Farley gave that 90-day extension after the date that the license expires. Well, Commonwealth versus Farley does not give an extension. What Commonwealth Farley says is that within 90 days, if you don't renew and you get caught, it's a civil fine for having an expired license. After 90 days, though, it becomes a criminal offense where you actually face jail time. Farley also says what makes you disqualified. And if any of these events happen, you have to turn in you lose your license because they're automatic disqualifiers. Well, he was claiming that being charged with a criminal offense was an automatic disqualification for a firearm license, and that gives the police the ability to revoke the license. Well, there's a problem with that. Commonwealth versus Farley in all laws actually do not give being charged with a criminal offense an automatic disqualification. Being found guilty of an offense is an automatic disqualification, not merely being charged with a criminal offense. Judge didn't care that ADA Hobbs lied about that, which is pretty screwy, actually. So, now let's get to what I wanted to have as the jury instructions. Oh yeah, also, someone in the courthouse had removed my motion to dismiss from the file, from the official file, before the motion to dismiss was heard. So the ADA provided a copy of that to the court on the day of the motion being heard. My motion to reconsider was also removed out of the case file, which had to be provided to him a second time because someone's taken information out of the case file. Someone who's working in the Springfield District Court is removing paperwork from the file before it's being even heard, before the judge even gets it. Who knows what's been removed since? So we have someone who works for the District Court Department who's got pretty sticky fingers when it comes to my case files, which is illegal. It's bullshit. And also, my witness list had been removed out of the case file, and my exhibits that I had presented to the court had been removed out of the case file. This is highly illegal and unethical that someone in the Springfield District Court is actually removing things from the file. So let's see what we got here. This is what I provided the court as a sample jury instructions. Now comes the defendant in the above entitled action and respectfully moves this honorable court to establish the use of Mr. Donnelly's simple jury instructions in this case. Did the Commonwealth prove that on May 7th, 2021, that Mr. Donnelly had an unexpired Massachusetts Class A license to carry? Yes, the Commonwealth did prove. No, the Commonwealth did not prove. Pretty simple, right? That on or before May 7th, 2021, did the Commonwealth prove that Mr. Donnelly had paid for the renewal of his Massachusetts Class A license to carry, and that the City of Springfield's Police Department had filed said renewal with the Commonwealth of Massachusetts and provided Mr. Donnelly with a receipt for fees paid. Yes, the Commonwealth did prove. No, the Commonwealth did not prove. Did the Commonwealth prove that on May 7th, 2021, that Mr. Donnelly had any firearms located within the Commonwealth of Massachusetts? Yes, the Commonwealth did prove. No, the Commonwealth did not prove. If you have replied yes to any of the above statements, you must convict. If not, you must find Mr. Donnelly not guilty. Pretty simple, right? Well, there's another one in there too, which I should have put in, which I forgot or just oversighted, because that's pretty simple. Did the city of Springfield serve in writing a suspension, or actually not even a suspension, because they didn't write suspension in their application. They sent a revocation in their official complaint. They're not even claiming suspension in their official complaint, which I was never given a revocation letter anyways, just a suspension one, so that shouldn't, but it's like this. They should have said, did the city of Springfield provide Mr. Donnelly with a revocation letter in writing per Mass General Law on or before May 7th? Fuck. The city of Springfield never provided me with a revocation letter, nor did they ever revoke my license as they had written in their application for criminal charges. They had suspended it until the Palmer case was over. And still, per Mass General Law, that suspension letter was supposed to be served in writing to me. Could have even been certified mail. But guess what? They never did that. It was only given to me in writing after I'd already been charged, arrested, had my clothes cut off my body, filmed like that, and had my rights completely trampled on and violated, including my Second Amendment right to have firearms in another state where I was still legally allowed to own, because over their lies and their willful violation of Mass General Law, I was ordered to turn in firearms that were in Vermont, that were legally in Vermont, to the Springfield Police Department, who went to Vermont and actually illegally confiscated those firearms. So, if you look at this, very simple. Very simple. Yes or no. This, or this. Simple enough where the common person can understand it. But, no. Nope. The judge refused that. And the judge says, I'm making up my own jury instructions for this case. He said that last Friday. Well, Friday before this past one. I went before him again Friday and asked him if he had the jury instructions ready. He doesn't. So I'm going to get the jury instructions on the day of trial. Is that fair? Is that right? I don't think that's fair. I don't think that's right. I think I should have been notified of the jury instructions before the day of trial so I could look at them and file anything that needs to get filed before I'm actually going before a jury and arguing what he's claiming are the jury instructions. Because you know, and I know, we both know, ADA Hobbs is going to have a copy of those jury instructions well before me. Why? Because we're looking at corruption. And remember something. The judge had his head on his head, hemming and hawing, saying, I'm reopening it with the motion to dismiss. You know, like, you never served him the way the law is written. All of this good stuff, right? All of that. But then he keeps on telling me, take the plea. Take the plea bargain. Is the plea bargain there? Is it still on the table? Is the plea bargain still on the table? No, it's not. Like, Mr. Donnelly, you're facing 2.5 years in jail here. Like, you don't want to take that plea bargain? Oh, now it's a continuous without a finding? Where you're saying that the Commonwealth has enough evidence to find you guilty? But you just want to you're taking a quaff? Are you sure you don't want to take this plea bargain? Are you sure you don't want this lawyer I want to give you to help you now? How about this, Your Honor? How about you grow a set of fucking balls and you actually do what is right and you dismiss these charges based upon the simple fact the city of Springfield violated Massachusetts General Law, Chapter 140, Section 131, by not providing me in writing with the suspension letter prior to them filing criminal charges against me. How about you do that? How about you grow a set of fucking balls and say, I am dismissing these charges because the city of Springfield, Massachusetts, violated Massachusetts General Law 140, 131 by not providing Mr. Donnelly with the suspension letter in writing prior to the charges being filed against him and him being arrested. I'm supposed to be a slave. We're supposed to be slaves. We're supposed to follow laws. And when we do follow the laws to the letter, we get arrested. We have our clothes cut off while being filmed, while stripped to a fucking bed. Yet, when the state and city, the state meaning Assistant District Attorney Hobbs, openly and willfully lies to the judge, he's allowed to. When the city of Springfield violates Mass General Law 140, 131 by not providing in writing the suspension notice prior to them filing charges, saying I did not comply, even though the license was expired anyways. So even discarding the fact the license was expired, and I didn't have a license to provide them because it was expired. But they were still in violation of Mass General Law anyways, because they never served me in writing as the law says in black and white. And there is case law dictating this too. There is case law that states that the law is to be taken as it is written and not to be expanded upon. It is written in black and white. City of Springfield is required under Mass General Law to provide in writing that a license is either suspended or revoked and give the reason why. And that is in order for you and me to be able to go to court and argue to get our license back in order to prove that there was no justification. And I'll be honest, I could have argued it. I could have appealed. But the reason why I didn't appeal is simple. I'm going to appeal their suspension, right? That was only good until the Palmer case was resolved, right? But now I'm facing the Springfield case, which the Springfield case was filed after the Palmer case, which means that my firearms were already ordered, turned in through this case right here, the Springfield case. So I figured by the time the Springfield case is situated and finished, the Palmer case is going to be long done anyways. So why am I going to appeal? Why am I going to waste my time filling motion after motion and going to court and going before a judge in order to appeal the suspension when the Palmer case is going to be done before the Springfield case anyways, which has been done, which right now, legally speaking, I should have already been given back my firearms, and they should have contacted me like I'd contacted them and asked how to go about getting my license now that back, how to get it renewed now that the Palmer case is over. So yeah, like instead of wasting my time and energy and effort and money filing another legal proceeding in order to squash the suspension, I figured, whatever. Like, you know, like the conditions in this case are going to outlast that anyways. So I took the best route that was going to save me the less headache, less aggravation, and everything else just by going with the suspension until the Palmer case was over. Well, anyways, it's getting late. We've already been doing this for 45 minutes. You probably already clocked off anyways a long time ago because, well, you probably don't want to hear me rambling. So, if you're not doing anything on April 28th, I believe it's a Thursday. So, April 28th, if you're not doing anything, come down, whether you love me, hate me, want to see me in handcuffs, or want to see me a free man. Come down to Springfield District Court and ask them at 9 o'clock in the morning, which courtroom is the Commonwealth versus Jeffrey Donnelly happening in? Because I want to see this jury trial. I want to watch this non-attorney, Mr. Jeffrey Donnelly, going against Assistant District Attorney Hobbs in front of the corrupt Judge McKenna. I want to watch this. I want to see exactly what is going to happen during this case. So, Thursday, April 28th, a couple weeks, a couple days after my birthday. Birthday present to me, who knows? Bracelets or freedom. But no matter what, everything's being appealed from this motion to dismiss because it's completely hogwash and bullshit. So, come on down. You know, if you like Judge Judy, Judge Mathis, Joe Brown, People's Court, like divorce court. You know, after all, going against the Commonwealth of Massachusetts does seem like a very, 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 may I say, bad breakup. Hell, I've never had any exes be this vindictive as the Hampden County District Attorney's Office is to me. I've dated some bad girls. Some horrible girls. Shit, I had one want to stab me because I said hi to a different girl, but hey. She was even a better ex than... And she cheated on me too. But still, she was even a better ex than the Hampden County District Attorney's Office has been, you know, towards me. Like, damn. I'm telling you, they're like that fucking stalker ex. They're like the ex that's stalking you. Like, the ex that's like hiding under your windows with the binoculars pressed to them. That's the ex that the Hampden County District Attorney's Office is to me. You know, it's a crazy one. But crazy type. So anyways, come down, love me, hate me, or just want to see one hell of a trial. Come on down. And if you want, you can wear a mask. And guess what? The courts are allowing you not to wear masks now. So you don't even have to wear the mask. Just come in. I'm here for the Donnelly case. Yeah. Okay. Well, good night.